Good morning, everybody. Martha Coakley, Attorney General. On my right is the Bureau Chief of the Public Protection and Advocacy Bureau, Jeff Clements, and on my left is the Division Chief of Consumer Protection, Chris Barry-Smith. This morning, after much work and analysis of some of what's been happening in the market and to consumers around subprime mortgage lending, we are taking an immediate action. At noontime today, we are filing an emergency set of regulations that defines unfair and deceptive certain foreclosure rescue schemes. They will be effective when filed. They are effective for 90 days. And they will be part of what is an ongoing process over the summer that I'll talk about briefly around determining what further regulations the Attorney General's office should adopt in order to protect consumers and frankly to balance out the market and protect what's been happening to cities and towns, for instance, is when properties have been abandoned. What I want to stress is that we do not take this action lightly. It has been 1998 since the Attorney General's office has adopted emergency regulations, but we believe that the actions that are prohibited by these regulations are so egregious, and we have brought several civil suits trying to hold people accountable for the rescue schemes. And because the harm that's done when they are effective is often irreparable for the borrower, we felt that it was important to make them effective immediately. What it means essentially is that it is now under 93A unfair and deceptive by regulation to, for profit, take equity in the home of someone who's seeking assistance in a foreclosure proceeding. It does not exclude a family member or nonprofit groups from assisting people who are in difficult situations. But our concern is the predatory rescuer, so to speak, the person who sees a profit in going to a family or an individual who is in dire straits as it is because the bank is about, or mortgage company is about to foreclose on the mortgage and offers assistance. It's illusory assistance. Usually what it means is signing over the deed to the house, and the lender then, the borrower, excuse me, is not only out of his house, he's out of any equity that might have been left in the house, and unfortunately ends up with no home and no equity and no defenses. And so we felt it was extremely important to issue today that those foreclosure rescue schemes are unfair and deceptive acts. If people believe they are subject to them and wish to consult our office, they should contact us. I would note that we've brought some suits based upon this practice. We have received several complaints, and we're in the process of investigating more complaints, and we urge anybody who believes that they have been victimized in one of these predatory rescue schemes to contact our office so that we can evaluate it. The second thing that we're announcing this morning that we have been in the process of establishing, because we also believe that although many of these risky loans and many of the loans where individuals are losing their homes are technically legal, so we cannot bring action against them, that individuals may benefit from the assistance of lawyers who can help them perhaps determine if bailouts can be worked, if there are legal defenses that could be brought into a court. And to that end, I have asked our of-counsel Carol Kenner. She's an Assistant Attorney General. She's the former Chief Justice of the Appellate Bankruptcy Court of the First Circuit. She works for the Attorney General's office now, and she has convened with the Mass Bar and the several of the Boston Bar, Minority Bar Panel, and Volunteer Lawyers Project, and others, a training on June 20th and 21st here. We are intending to provide for those individuals who believe they have legal defenses or other ways they may accomplish bailouts to provide counsel for them. So we will set up a referral hotline with attorneys who are trained, who on a one case-by-case basis may be able to assist those who are in the process of having their houses foreclosed on. That would be a pro bono activity, as I mentioned, of the bars involved. And we urge any lawyers, large firms or small, people with real estate experience who are interested in assisting in this particular project to contact the Boston Bar. That number is 617-778-1936, I believe. I can check that number. We stress again that these will be pro bono attorneys who can consult, as we are not able to individually in the Attorney General's office, with those who are in the process of foreclosure proceedings and at risk for losing their homes. The third announcement this morning is that because of the incredible impact on consumers, as I mentioned earlier, on the market, and particularly on some of our urban areas, the Attorney General's office is, as of today, beginning a 21-day period of comment in which we are asking anyone who has interest in further regulations, consumer groups, the mortgage industry, banking industries, trade groups, to solicit their opinions on further regulations that we are interested in under Chapter 93A, Section 2C. We will have a 21-day period of comment, and we will have hearings over the summer to determine what, if any, further regulation should be adopted. Included in that, of course, will be hearings around the emergency regs that go into effect today, but it is a much broader scope of a hearing. We are intending to solicit information around such practices as inflating incomes of borrowers, no documentation or low documentation loans. We intend to solicit comments on whether or not it's an unfair or deceptive practice for lenders to make loans that are not in the best interest of the borrower, particularly when it should be apparent to the lender that the individual accepting the loan, taking the loan, does not have the ability to repay it. And we specifically note that many of these foreclosure loans have resulted when there's a low interest rate for 2 years with a balloon rate at the end of that 2-year or 3-year period. There's been no analysis done in many of these as to whether that individual getting that loan is going to be able to pay that loan. And in fact, if you looked at the document, you could assume they would not be able to pay the loan when the interest rate balloons at the end of that individual period. So that's one of the areas we're interested in looking at. We also want to explore, and we're asking for comments on the practices of lenders around credit qualification and whether they have the appropriate criteria to make loans to consumers. And finally, we are also soliciting comments on whether or not the Attorney General's office should consider it an unfair or deceptive practice to allow lenders to assign loans without any ability for the individual borrower to be able to bring claims or credits. In other words, if a loan is originated under Massachusetts law, and there are certain defenses against foreclosure, what's happened in many instances is that loan gets sold off up the chain, often out of state to a national company. The assignee, the person who takes the loan, says, I don't have to answer to what those claims or defenses may be of the loan originator, and we want to look carefully at whether certain of the practices that have resulted, we believe, in the huge number of foreclosures, not only in Massachusetts, but obviously around the country, should be deemed to be unfair and deceptive. In short, what we are trying to do is provide as much assistance in the short run by making these foreclosure rescue schemes clearly unfair and deceptive, by providing legal assistance for those who may be able to work out some of their loans or have legal defenses, and most importantly, as we go forward, trying to make sure that this kind of crisis doesn't occur again as we look at appropriate regulation for those who are originating loans and who are selling them off in a secondary market. I would note that in the last 60 days, there have been over 4,200 foreclosure proceedings that have begun in Massachusetts. As you might imagine, they are higher in some of our more dense counties, but Worcester County has over 600, Suffolk County has over 500, Middlesex has over 600. And my understanding from talking to my staff and talking to people in the field is that the year 2006 was probably the high watermark for loans originated according to some of these practices that we've talked about. So although there has been a dip recently in foreclosures, we cannot predict that this will go away soon, and that there will be an increasing, at least over the next year or two, increasing numbers of foreclosures based upon the practices around originating subprime mortgage loans. We have provided to you some information, a copy of the regs. We've also, I want to stress, made it as easy as possible for people to comment on these practices. They can go onto our website, they can fax us information, and I stress that it's important for us to hear from everybody who's affected by these loans, both as borrowers, consumers, and those who deal in the mortgage industry and banking industry, to assist us with this process, which I think is important not only for consumers in Massachusetts, but for mortgage and lenders who play by the rules and who are fair in originating of loans.